other exemptions to the H1B are if you have a teaching hospital, they may qualify. In that teaching hospital, that's basically a residency program, so they need to have an agreement demonstrating the affiliation between the hospital and the university in order to be cap exempt. And then institutes of higher education or nonprofits affiliated with the institution of higher education, basically that is another way that would allow someone to be cap exempt. Nonprofit government research organizations and nonprofit research organizations also qualify, and for-profits would qualify if you have someone spending a majority of the time at the nonprofit. Now I'm going to move on to the H-1B process. So if you have someone on a Conrad 30 program after the J1 waiver is approved, then you file the H-1B petition, or we would file the H-1B. And what we'll do is we have to make sure that they're being paid the market wage rate. Usually physicians, there's not a problem with that. And we follow the application. Right now, applications are taking anywhere from about 2 to 5 months for approval. And if you want a faster decision, we could always file premium processing. The H-1B change of employer, also known as the H-1B transfer process, can allow physicians, as soon as the application is filed and we get a receipt notice, to start working immediately. But I recommend that you wait until get the approval notice before they start working in order to make sure that everything proceeds smoothly when applying for an H-1B change of employer. Now, if you have a physician who is filing for an H-1B change of employer and is in the Conrad 30 program, this is not a normal H-1B change of employer. It's a lot more difficult to get an H-1B change of employer approved. You have to show extenuating circumstances. So that would be something like where the facility that they are currently working at is not honoring the contract, or if they're separated from their spouse, that may qualify. Those are some examples of possible extenuating circumstances. And the latter example that I gave, that's not a great form of extenuating circumstances where the spouses are separated, but it could qualify. If they have a child, then it would depend upon how that all ties into the whole story. So basically, you just want to think, is it going to cause a real significant hardship on the physician? And is that hardship going to be resolved by changing to a new employer? And so every case is a case-by-case basis, basically, that we would look at. And if, for instance, you had a doctor who had a child and needed to have both spouses present, I would think we could make an argument that that would be extenuating circumstances.